Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload new content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click that notification bell so you can be updated every time we do upload new content. Let's get going with question number one. Question number one. Staff Inc., a flour wholesaler, contracted to deliver to Eclair, a producer of fine baked goods, her flour requirements for a 1-year period. Before delivery of the first scheduled installment, Staff sold its business and assigned all of its sale contracts to Miller Inc., another reputable and long-time flour wholesaler. Staff informed Eclair of this transaction. For this question only, assume that Eclair accepted Miller's delivery of the first installment under the Staff-Eclair contract, but that Eclair paid the contract price for that installment to Staff and refused to pay anything to Miller. In an action by Miller against Eclair for the contractual amount of the first installment, which of the following, if any, will be an effective defense for Eclair? 1. Eclair had not expressly agreed to accept Miller as her flour supplier. 2. Eclair's payment of the contractual installment to Staff discharged her obligation. Or 3. Staff remained obligated to Eclair even though Staff had assigned the contract to Miller. Which of the three are correct? 1 only, A, 1 only, B, 2 only, C, 1 and 3 only, or D, neither 1, nor 2, nor 3. Take 10 seconds and choose the best answer now. If you chose option D, neither 1 nor 2 nor 3, you'd be correct. Assignment is a transfer of rights or benefits under a pre-existing contract to a third party. The two elements necessary for a proper assignment are a valid contract between two parties, and one party to the contract transfers rights or benefits under a contract to a third party. In an assignment, the assigner is the party who makes the assignment. The assignee is the party who was not a party to the original contract but is the recipient of the agreement. And the obligor is the one party to the original contract who owed performance to the assigner. A payment by the obligor to the assigner is legally effective until the obligor is notified of the assignment. Here, Staff assigned its contract with Eclair to Miller, and Staff informed Eclair of this transaction. Staff is the assigner. Miller is the assignee, and Eclair is the obligor. While Eclair accepted Miller's performance under the assignment when she accepted Miller's flour delivery, this was not necessary for the assignment to be valid. Eclair's payment to the Staff for the delivery does not discharge her obligation to pay Miller because she was already notified of the assignment. While Staff does remain obligated to Eclair because Staff is an original party to the Staff-Eclair contract, the fact does not change Eclair's obligation to pay Miller for delivery of the first installment. As such, none of these will be effective defenses for Eclair. Question number 2. Pamela sued driver for damages for the death of Pamela's husband Ronald, resulting from an automobile collision. At trial, driver calls Ronald's doctor to testify that the day before his death, Ronald, in a great pain, said, "It was my own fault. There's nobody to blame but me." The doctor's testimony should be admitted as A, a statement against interest, B, a dying declaration, C, a statement of Ronald's then existing state of mind, or D, an excited utterance. Take 10 seconds. If you chose option A, you'd be correct, a statement against interest. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. A hearsay statement is admissible if at the time it was made the statement was against financial interest of the declarant or would have subjected the declarant to criminal liability. A hearsay statement made under the belief of impending death and describing the cause or circumstances leading to this impending death is admissible in a civil action and a homicide prosecution. The declarant does not have to die but must be unavailable. Here, Ronald's statement does not qualify as a dying declaration. Ronald was in great pain when he made his statement, and he died the following day, but there's no indication Ronald believed he was going to die at the time he made his statement. Ronald's statement, however, is a statement against interest, since Ronald admitting fault for the accident is certainly against his financial interest. Therefore, the doctor's testimony should be admitted as a statement against party interest. Question number 3. Perkins and Morton were passengers sitting in adjoining seats on a flight on Del Val Airline. There were many empty seats on the aircraft. During the flight, a flight attendant served Morton 9 drinks. As Morton became more and more obviously intoxicated and attempted to engage Perkins in conversation, Perkins chose to ignore Morton. This angered Morton, who suddenly struck Perkins in the face, giving her a black eye. If Perkins asserts a claim for damages against Del Val Airlines based on battery, she will A. prevail because she suffered an intentionally inflicted harmful or offensive contact. B. prevail if the flight attendant acted recklessly in continuing to serve liquor to Morton. C. not prevail because Morton was not acting as an agent or employee of Del Val Airline. Or D. not prevail unless she can establish some permanent injury from the contact. Take 10 seconds and choose your best answer now. If you chose option C, you'd be correct. Not prevail because Morton was not acting as an agent or employee of Del Val Airline. Battery is the intentional infliction of a harmful or offensive contact with a victim's person. If an employee commits a tort in the scope of her employment, her employer will be vicariously liable. An employer is generally not liable for the intentional torts of its employees unless the act was specifically authorized by the employer. The act was in the nature of employment, or the act was motivated by the desire to serve the employer. Here, Morton is the person who struck Perkins in the face. Morton was not an agent or employee of Del Val Airline, so Del Val Airline cannot be vicariously liable for Morton's action. Del Val Airline may be liable for Perkins' injury under a negligence theory for failing to better protect Perkins from an unreasonable risk of injury, but Del Val Airline will not be liable for Perkins' injury under a battery theory. Therefore, Perkins will not prevail because Morton was not acting as an agent or an employee of Del Val Airlines. Question number 4. Prine sued Dover for an assault that occurred March 5 in California. To support his defense that he was in Utah on that date, Dover identifies and seeks to introduce a letter he wrote to his sister a week before the assault, in which he stated that he would see her in Utah on March 5th. The letter is A. admissible within the state of mind exception to the hearsay rule. B. admissible as a prior consistent statement to support Dover's credibility as a witness. C. inadmissible because it lacks sufficient probative value. Or D. inadmissible because it is a statement of belief to prove the fact believed. Take 10 seconds. If you chose option A, admissible within the state of mind exception to the hearsay rule, you'd be correct. Under state of mind hearsay exception, a statement of present interest is admissible to prove conduct in conformity with the stated intent. Here, Dover's letter showed his then existing state of mind in intending to visit his sister on March 5th in Utah, the same day as the assault occurred in California. Therefore, the letter is admissible because it falls within the state of mind exception to the hearsay rule. Question number 5. At the trial of an action against grandmother on behalf of Patrick, the following evidence has been introduced. Grandson and his friend Patrick, both aged 8, were visiting grandmother's house. When exploring the premises, they discovered a hunting rifle in an unlocked gun cabinet. They removed it from the cabinet and were examining it when the rifle, while in grandson's hands, somehow discharged. The bullet struck and injured Patrick. The gun cabinet was normally locked. Grandmother had opened it for dusting several days before the boys' visit and then forgot to relock it. She was not aware that it was unlocked when the boys arrived. If the defendant moves for a directed verdict in her favor at the end of the plaintiff's case, the motion should be A. Granted because grandmother is not legally responsible for the acts of her grandson. B. Granted because grandmother did not recall the gun cabinet was unlocked. C. Denied because a firearm is an inherently dangerous instrumentality. Or D. Denied because a jury could find that grandmother breached the duty of care she owed to Patrick. Take 10 seconds. If you chose option D, denied, because a jury could find that grandmother breached the duty of care she owed to Patrick, you'd be right. A licensee is a person who enters the land with the owner's consent, but who does not have a business purpose for being there. The standard of care is reasonable care for activities on the land. For unknown concealed dangers, there is no duty to inspect. For known concealed dangers, there is a duty to warn. Where a defendant's conduct falls short of that level required by the applicable standard of care owed to the plaintiff, the defendant breaches the duty. Here, Patrick was a licensee because he was invited to grandmother's house as a social guest. For activities in the house, grandmother had to act as a reasonable, prudent person would under the circumstances. The hunting rifle was a known concealed danger because she normally locked the gun cabinet. Grandmother had a duty to warn Patrick of dangers involving the rifle. As such, grandmother breached her standard of care because she did not lock the cabinet as a reasonably prudent person would, and did not warn Patrick of the dangers involving the rifle. Thus, grandmother breached the duty of care she owed to Patrick. Question number 6. Plaza Hotel sued Plaza House Hotel for infringement of its trade name. To establish a likelihood of name confusion, Plaintiff Plaza Hotel offers a series of memoranda which it had asked its employees to prepare at the end of each day, listing instances during the day in which telephone callers, cab drivers, customers, and others had confused the two names. The memoranda should be A. Excluded because they are more unfairly prejudicial and confusing than probative. B. Excluded because they are hearsay not within any exception. C. Admitted because they are records of regularly conducted business activity. Or D. Admitted because they are past recollection recorded. Take 10 seconds. If you chose option B, excluded because they're hearsay without any exception, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is generally inadmissible. One hearsay exception is the business records exception. A record of events, conditions, options, opinions, or diagnoses recorded in a business record is admissible under a hearsay exception where the information was recorded by somebody under a duty to record or report such information, by somebody with personal knowledge of the information at or near the time of the matter described, and when the record was kept in the ordinary course of business. In this case, the written statements prepared by the employees would be offered to prove the truth of the matter asserted in those statements, i.e., that people had confused the two names. This is hearsay, not within any exception. The employees' written statements were not prepared as records kept in the ordinary course of business. In fact, they were prepared in anticipation of the current litigation. Thus, the memoranda should be excluded because they are hearsay, not within any exception. Question number 7. Landco purchased a large tract of land intending to construct residential housing on it. Landco hired Poolco to build a large in-ground swimming pool on the tract. The contract provided that Poolco would carry out blasting operations that were necessary to create an excavation large enough for the pool. The blasting caused cracks to form in the walls of plaintiff's home in a nearby residential neighborhood. In plaintiff's action for damages against Landco, plaintiff should A. Prevail only if Landco retained the right to direct and control Poolco's construction of the pool. B. Prevail because the blasting that Poolco was hired to perform damaged plaintiff's home. C. Not prevail if Poolco used reasonable care in conducting the blasting operations. Or D. Not prevail if Landco used reasonable care to hire a competent contractor. Take 10 seconds. If you chose option B, you'd be correct. Prevail because the blasting that Poolco was hired to perform damaged plaintiff's home. The rule is that a person is strictly liable for any harm which occurs while engaging in an abnormally dangerous activity, so long as the harm results from the kind of risk that made the activity abnormally dangerous in the first place. Safety precautions taken by the defendant are completely irrelevant. Furthermore, while the general rule is that one who hires an independent contractor is not liable for the torts of that independent contractor, a person will be liable for damages caused by an independent contractor hired to perform inherently dangerous activities. In this case, Poolco was hired by Lanco to carry out blasting operations, which are considered an abnormally dangerous activity. As such, Poolco will be strictly liable for any harm that results from these blasting operations, so long as the harm results from the kind of risk that made the activity abnormally dangerous in the first place. Since these blasting operations caused cracks in the walls of plaintiff's home, and since this type of damage resulted from the kind of risk that makes blasting abnormally dangerous in the first place, plaintiff will prevail in an action for damages against Lanco, who is vicariously liable for the damages caused by Poolco. Question number 8. In a prosecution of Doris for murder, the government seeks to introduce a properly authenticated note written by the victim that reads, "Doris did it." In laying the foundation for admitting the note as a dying declaration, the prosecution offered an affidavit from the attending physician that the victim knew she was about to die when she wrote the note. The admissibility of the note as a dying declaration is a preliminary fact question for the judge, and the judge must not consider the affidavit. B, a preliminary fact question for the judge, and the judge may properly consider the affidavit. C, a question of weight and credibility for the jury, and the jury must not consider the affidavit. Or D, a question of weight and credibility for the jury, and the jury may properly consider the affidavit. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. A preliminary fact question for the judge, and the judge may properly consider the affidavit. Under the Federal Rules of Evidence, the court must decide any preliminary questions about whether a witness is qualified, a privilege exists, or evidence is admissible. In so deciding, the court is not bound by evidence rules, except those on privilege. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is generally inadmissible. One hearsay exception, when the declarant is unavailable, is the dying declaration exception. A hearsay statement made under the belief of impending death and describing the cause or circumstances leading to his impending death is admissible in a civil action and homicide prosecutions. The declarant does not have to die but must be unavailable. In this homicide prosecution, the admissibility of the victim's note is a preliminary fact question that will be decided by the judge. The attending physician's affidavit is offered to prove the truth of the matter asserted in that affidavit, that the victim knew she was about to die when she wrote the note. Therefore, the affidavit offered to support admission of the note is itself hearsay. But because the judge is not bound by hearsay rules when deciding whether to admit the note, the judge may consider the hearsay affidavit. Therefore, the judge may properly consider the affidavit to determine the admissibility of the note as a dying declaration. Question number 9. After waiting until all the customers had left, Max entered a small grocery store just before closing time. He went up to the lone clerk in the store and said, "Hand over all the money in the cash register or you will get hurt." The clerk fainted and struck his head on the edge of the counter. As Max went behind the counter to open the cash register, 2 customers entered the store. Max ran out before he was able to open the register drawer. On this evidence, Max could be convicted of A, robbery, B, assault and robbery, C, attempted robbery, or D, assault and attempted robbery. Take 10 seconds. If you chose option C, attempted robbery, you'd be correct. In order to prove attempt, the state must show that 1, defendant intended to commit the crime, and that 2, he took a substantial step towards completing the crime. Regardless of the underlying crime, Attempt is always a specific intent crime. Abandonment is not a defense to attempt. Robbery is the wrongful taking of another person's property by force or threat of immediate harm with the intent to permanently deprive. Assault is the attempt to commit battery or the intentional creation of reasonable apprehension of imminent bodily harm. The merger doctrine applies when one crime is a lesser included offense of another crime committed at the same time. For example, robbery is a larceny plus force or threat of immediate harm, so larceny is merged into robbery. Similarly, assault can be merged into robbery if the robbery was committed with the threat of immediate harm. In this case, Max entered the grocery store with the intent of taking the grocery store's money through the threat of immediate harm. Max likely committed assault when he said, "Hand over all the money in the cash register or you will get hurt," because he created a foreseeable apprehension that the clerk would be imminently hurt. Max ran out of the store before he could open the cash register to complete the robbery, so Max is likely guilty of attempted robbery. However, Max would not be convicted of assault because it will get merged into the greater offense of robbery. Therefore, on this evidence, Max could be convicted of attempted robbery. On to question number 10. On November 15th, Joyner, in a signed writing, contracted with Gallery for an agreed price to personally remodel Gallery's kitchen according to specifications provided by Gallery, and to start work on December 1st. Joyner agreed to provide all materials for the job in addition to all of the labor required. For this question only, assume that on November 26th, Joyner, without legal excuse, repudiated the contract, and that Galley, after a reasonable and prolonged effort, could not find anyone to remodel his kitchen for a price approximating the price agreed to by Joyner. If 1 year later Galley brings an action for specific performance against Joyner, which of the following will provide Joyner with the best defense? A. An action for equitable relief not brought within a reasonable time is barred by laches. B. Specific performance is generally not available as a remedy to enforce a contractual duty to perform personal services. C. Specific performance is generally not available as a remedy in the case of an anticipatory repudiation. Or D. Specific performance is not available as a remedy where even nominal damages could have been recovered as a remedy at law. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. Specific performance is generally not available as a remedy to enforce a contractual duty to perform personal services. The rule is that there's no specific performance for service contracts. In this case, Joyner had contracted with Galley to remodel Galley's kitchen. About 2 weeks later, Joyner repudiated the contract without legal excuse. Galley cannot compel Joyner to resume and complete performance of the contract because there's no specific performance for service contracts. Thus, if Galley brings an action for specific performance against Joyner, Joyner's best defense is that specific performance is generally not available as a remedy to enforce a contractual duty to perform personal services. Thank you again for joining us on Bar10 Test Prep. It's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every single day at 8 a.m. Eastern Standard Time. Don't forget to click that bell, like and subscribe our page, and most importantly, as I said, click that bell so you can be updated every time we upload new content.